The moment everything shifted for nearly 100 million gun owners, something changed at the highest court in the nation. This wasn't a minor adjustment or a technical procedural tweak. It was a deep constitutional shift, one that could reshape how you carry, where you carry, and whether government authorities can stop you at all. For decades, law-abiding gun owners in states such as California, New York, New Jersey, and Maryland were placed in a position where they had to ask for permission. They had to ask for a permit. They had to convince a local official that their reason for self-defense was sufficient. They had to request approval for a constitutional right and hope the answer was yes. That entire structure is now facing sustained constitutional pressure from the Supreme Court of the United States. In a 6-3 decision that sent shockwaves across state governments nationwide, the justices did not simply review a single statute. They targeted the broader bureaucratic framework that had long controlled whether citizens could exercise the Second Amendment beyond their homes. Political leaders who support stricter gun laws immediately recognize the scale of what may follow. If you want the unfiltered legal reality, every shift in doctrine, every implication, every practical consequence, you're in the right place. No spin, no partisan framing, only the legal developments shaping rights now and in the future courtroom battles ahead. Here's what this breakdown covers, what the 6-3 ruling actually establishes, and why its impact goes beyond headlines, the century-long history of permit systems now. Under scrutiny, how states are responding and the strategies they are using to maintain existing regulations, the new. Constitutional standard now guiding Second Amendment litigation. What this means for law-abiding gun owners, starting immediately, let's begin. The ruling arrived with decisive constitutional force. 6 justices formed the majority and 3 dissented, but the numbers alone do not capture the scale of the decision. This was not a narrow outcome. It was a clear constitutional majority, one that lower courts cannot easily reinterpret or sidestep. At the center of the case was a challenge to a may-issue permitting system. Under this framework, citizens were required to demonstrate a proper cause or good cause before being allowed to carry a handgun in public. In practical terms, individuals had to persuade a government official that their personal need justified exercising a constitutional right. The court rejected that requirement. The majority opinion established several key points. The Second Amendment protects the right to carry firearms in public for self-defense, not only within the home. A proper cause or a good cause standards are unconstitutional. Constitutional rights do not require individuals to provide justification before exercising them. The right to bear arms does not end at a home's threshold. States cannot base permit approvals on subjective judgment by officials. The dissent warned about potential public safety consequences, arguing that states should retain flexibility to regulate firearms in public environments. The majority, however, emphasized constitutional interpretation over policy concerns. Before this decision, only a limited number of states operated under shall-issue permit systems with relatively objective standards. Others allowed officials broad discretion to approve or deny permits. The ruling places those discretionary systems under direct constitutional review. Permit systems themselves did not appear suddenly in modern law. They developed across more than a century. Understanding the significance of this ruling requires stepping back historically. 1865, the Black Codes following the Civil War, several southern states enacted laws restricting firearm access for newly freed Black Americans. These measures functioned as control mechanisms rather than neutral public safety policies. 1911, the Sullivan Act, New York, enacted one of the first major urban firearm permitting laws. The law's sponsor, Timothy Sullivan, was a prominent political figure associated with urban political networks. Historical analyses often note that immigrant populations were among those most affected. 1968, the Gun Control Act passed after the assassinations of Robert F. Kennedy and Martin Luther King Jr. This federal law created modern background check structures while also expanding regulatory authority over firearm sales. Throughout the 20th century, states, particularly urban jurisdictions, expanded permit requirements by adding fees, training mandates, waiting periods, and discretionary approval standards. courts rarely intervened. Over time, the Second Amendment was often interpreted differently from other constitutional protections such as speech or religion, receiving narrower judicial scrutiny. Statistics frequently cited in legal debates highlight how restrictive some systems became. In certain jurisdictions, only a small fraction of adults obtained concealed carry permits. This ruling aims to reassess that structure. Importantly, the decision did not emerge in isolation. It builds directly on a constitutional shift that began in 2022. The foundation comes from the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruen, issued in June 2022. That ruling significantly changed how courts evaluate gun regulations. Before Bruen, courts commonly used a two-step framework. 1. Determine whether the activity fell under the Second Amendment. 2. Balance the government's regulatory interest against the burden on the right. In practice, public safety arguments often dominated the analysis. And why? The Bruen decision replaced that framework entirely. Instead, the court established a new evaluation method based on text, history, and tradition. Under this standard, courts must first examine whether the Second Amendment's text covers the regulated conduct. If it does, the government must demonstrate that the regulation aligns with historical firearm restrictions from the founding era or Reconstruction period. Modern policy arguments alone are insufficient. The recent 6-3 ruling applies this framework directly to public carry permitting systems, extending the impact of the Bruen decision. In doing so, it places discretionary permitting structures under intense constitutional scrutiny. Following the establishment of the text, history, and tradition standard, the legal consequences began unfolding rapidly across the country. Courts, legislatures, and regulatory agencies immediately recognized that the framework introduced in Bruen and reinforced by the new 6-3 ruling reshape how nearly every firearm regulation is evaluated. Within days of the decision, state governments began reviewing their existing statutes. Some jurisdictions moved quickly to adjust language in their laws, while others prepared to defend current restrictions through new legislative strategies. In several states, officials focused on redefining what are known as sensitive places, locations where carrying firearms can be restricted. Public spaces such as parks, transportation systems, entertainment venues, and large commercial areas were added to expanded lists of restricted zones. Supporters of these measures argued that they were necessary for public safety. Critics argued that overly broad restrictions could effectively limit lawful carry in most urban environments. Meanwhile, legislatures in multiple states introduced new procedural requirements tied to permits, including liability insurance mandates and expanded training standards. These actions reflected a broader legal strategy, maintaining regulatory authority while adapting to the new constitutional test. At the same time, states with existing constitutional carry frameworks publicly stated that the ruling reinforced their current laws. Several legislatures began reviewing remaining permit structures to ensure alignment with the evolving judicial interpretation. Gun rights organizations moved quickly as well. Legal groups filed new lawsuits across numerous jurisdictions, challenging discretionary permitting rules, and recently enacted regulatory expansions. Litigation activity increased dramatically within days of the ruling, signaling that the decision would not remain confined to a single case. The pace of legal filings illustrates how significant the shift has become. The new framework is now being used as the primary argument in challenges to a wide range of firearm laws. This legal momentum did not appear unexpectedly. It follows a pattern that began immediately after the 2022 Bruen decision. Justice Clarence Thomas, writing for the majority in that case, emphasized that constitutional rights cannot depend on subjective approval processes. His opinion clarified that historical tradition, not modern policy preference, must guide Second Amendment analysis. Since that decision, federal courts have applied the text, history, and tradition standard to multiple categories of firearm regulation. Some laws have been struck down, while others remain under review as appellate courts continue refining how the standard should operate in practice. As legal challenges expanded, state-level responses grew more complex. One common legislative approach involved expanding definitions of restricted locations. By increasing the number of designated sensitive places, states attempted to regulate where firearms could be carried without directly reintroducing discretionary permit systems. Another strategy involved financial requirements. Liability insurance proposals and increased administrative fees were introduced in several jurisdictions, creating additional procedural steps for applicants. Supporters described these policies as accountability measures. Opponents argued they could function as indirect barriers. Training requirements also became a focal point. Some states proposed extended classroom instruction and live fire certification requirements, exceeding previous standards. Legal analysts immediately began debating whether these measures could survive under the historical tradition test established in Bruen. Emergency legislative sessions became another tool. Some states passed rapid response statutes intended to maintain regulatory continuity while litigation continues. Federal district courts have already issued injunctions in several cases where new laws were considered inconsistent with constitutional precedent. As litigation spreads, the number of active Second Amendment cases has increased substantially across federal circuits. The evolving legal environment reflects a broader structural shift. Courts are no longer evaluating firearm regulations primarily through modern policy analysis. Instead, historical comparison has become the controlling factor. This change has altered how attorneys argue cases and how judges evaluate constitutional claims. Previously, courts often relied on statistical arguments or public safety research when determining whether a law was reasonable. Under the new framework, historical documentation now carries greater weight than contemporary policy analysis. Legal scholars note that this transition is reshaping courtroom strategy nationwide. The framework itself follows a three-part structure. Step 1. Text courts determine whether the Second Amendment's wording covers the conduct being regulated. Step 2. History. If the conduct falls within the amendment scope, the government must identify historical regulations from the late 18th or 19th centuries that are comparable to the modern law. Step 3. Tradition courts evaluate whether the historical examples demonstrate a consistent legal tradition supporting the restriction. If sufficient historical analogs are not found, the regulation may be considered unconstitutional. This approach represents a major departure from previous balancing tests. Under the earlier method, courts often asked whether a law served an important governmental objective. The new framework instead asks whether similar restrictions existed when the constitutional provisions were adopted. Because of this shift, several categories of firearm laws are now facing renewed constitutional challenges. Among the most frequently litigated areas are magazine capacity limits, waiting periods for firearm purchases, restrictions tied to specific firearm configurations, expanded sensitive place definitions, permit-related financial requirements. Many of these cases remain ongoing. With appellate courts reviewing lower court decisions, the broader effect is clear. The legal landscape surrounding the Second Amendment is undergoing rapid structural change. For law-abiding gun owners, the practical implications depend heavily on location. In states that previously used discretionary permitting standards, application processes may change as lawsuits proceed. Some jurisdictions are transitioning toward objective criteria, while courts determine whether older systems remain constitutional, constitutional. For individuals who already hold permits, regulatory boundaries, particularly sensitive place restrictions, may continue evolving over the next several years. Interstate reciprocity remains unchanged for now. National reciprocity would require federal legislation rather than judicial interpretation. However, legal experts note that the recognition of public carry as a constitutional right strengthens arguments for future legislative proposals addressing reciprocity. Individuals previously denied permits under discretionary standards may also see new legal pathways, depending on how courts apply the updated framework. As these changes continue unfolding, attorneys specializing in constitutional and firearms law are closely monitoring new rulings across federal circuits. The legal process is far from complete. The 6-3 decision did not end the debate. It intensified it. Political reactions began immediately at both federal and state levels, signaling that legislative responses will continue alongside judicial review. The political response to the ruling developed almost immediately, demonstrating how deeply the issue reaches into federal and state policy making. In Washington, lawmakers introduced new proposals aimed at redefining national firearm standards. Several members of Congress argued that federal legislation could establish updated regulatory frameworks consistent with public safety objectives, while others maintained that the court's interpretation limits how far such legislation can go. Within days, discussions began around new permit-related frameworks and broader regulatory proposals connected to concealed carry policies. The United States Department of Justice also initiated internal reviews to evaluate how existing federal enforcement policies might be affected by the ruling. These reviews focused on determining whether current regulations align with the constitutional interpretation reinforced by the court. At the same time, public statements from the White House expressed concern about potential public safety implications. Federal officials emphasized the importance of balancing constitutional protections with enforcement priorities. In Congress, legislative debates intensified. Senators Chris Murphy and Richard Blumenthal announced plans for hearings focused on the evolving interpretation of the Second Amendment and its impact on federal law. Meanwhile, committees in the United States House Committee on the Judiciary began advancing discussions related to interstate concealed carry recognition. Supporters of reciprocity legislation argue that if public carry is constitutionally protected, valid permits should be recognized across state lines. Opponents argue that states must retain authority to establish their own regulatory frameworks. At the state level, reactions were equally strong. In California, Governor Gavin Newsom announced discussions around potential constitutional amendments at the state level aimed at clarifying regulatory authority. Other states moved in the opposite direction. Legislators in Texas and Florida issued statements describing the ruling as consistent with their existing constitutional carry policies. Additional legislative reviews were announced to determine whether remaining procedural requirements should be updated. Several states, including Ohio and Tennessee, introduced proposals examining whether further regulatory adjustments are necessary under the new judicial framework. The political impact is already extending toward upcoming election cycles. Advocacy organizations on both sides of the issue have begun increasing voter outreach efforts, recognizing that firearm policy remains one of the most influential constitutional topics in national politics. Polling organizations continue to report that firearm ownership affects tens of millions of households across the United States, meaning legal developments in this area often carry broad political implications. While legislative debates continue, the legal consequences of the ruling are expanding into additional categories of firearm regulation. The decision's most significant effect may not be limited to carry permits. It may influence how courts evaluate nearly every existing gun law. Legal challenges are already underway in multiple areas. One category involves restrictions on specific firearm configurations, often referred to in litigation as assault weapon bans. Appellate courts are currently reviewing cases addressing whether historical analogs exist for modern configuration-based restrictions. Another major category involves magazine capacity limits. Several federal district courts have already issued rulings analyzing whether historical precedent supports limits on ammunition capacity. These cases remain active, with appellate courts continuing to evaluate how the text, history, and tradition framework applies. Waiting period laws represent another area under legal review. Plaintiffs in several states argue that no direct historical equivalent exists for mandatory waiting periods prior to firearm purchases. Courts are now examining historical firearm acquisition practices to determine whether comparable regulatory traditions existed. Red flag laws, also known as extreme risk protection orders, are being evaluated under both Second Amendment standards and due process considerations. These laws allow temporary firearm removal through court orders when individuals are considered a risk. Because these statutes involve both constitutional rights and procedural safeguards, courts are addressing them through multiple legal frameworks, simultaneously. Another evolving legal issue involves categorical firearm prohibitions tied to specific legal statuses. A recent appellate case reviewed restrictions connected to domestic violence restraining orders. While the United States Supreme Court ultimately reversed part of the lower court's analysis, the broader constitutional questions remain active in ongoing litigation. Legal analysts estimate that hundreds of federal and state firearm regulations currently exist across the country. Under the text, history, and tradition framework, many of these laws may face renewed constitutional review over the coming years. This shift has opened what many observers describe as a new phase of Second Amendment litigation. For decades, most major firearm cases focused on defending existing regulations. Now, increasing numbers of lawsuits are challenging regulatory structures directly. This transition marks a strategic change in how constitutional litigation is unfolding. Gun rights organizations are filing cases across multiple federal circuits, while state governments are preparing legal defenses designed to demonstrate historical precedent supporting their laws. The outcome of these cases will likely determine how broadly the new constitutional framework is applied. Beyond the courtroom, the ruling is also influencing public discussion about constitutional interpretation itself. Legal scholars across the ideological spectrum are debating how historical analysis should function when applied to modern regulatory environments. Some scholars argue that historical frameworks provide clearer constitutional boundaries. Others argue that modern conditions require more flexible interpretation. These debates are expected to continue as courts issue additional rulings. Despite the ongoing political and legal activity, one point remains clear. The ruling did not conclude the issue, it expanded it. The legal process now moves into a longer phase involving appellate review, statutory adjustments, and continued constitutional challenges. Stepping back, the ruling marks a fundamental shift in how the Second Amendment is treated. For nearly a century, it was often viewed as a conditional right, a right that existed on paper but could be limited, regulated, or delayed in practice. Courts allowed this, politicians leveraged it, and millions of law-abiding gun owners were forced to navigate a system that presumed their right was dangerous until proven otherwise. That presumption has now been reversed. The Supreme Court, with a durable 6-3 majority, has made it unequivocally clear. The Second Amendment means what it says. It is no longer a second-class right. It does not require permission slips. It does not yield to bureaucratic discretion or political preference. This decision places the Second Amendment on equal constitutional footing with the First, Fourth, and every other right enumerated in the Bill of Rights. Its implications go far beyond carry permits. The ruling establishes that constitutional rights are not negotiable based on political climate. They are foundational and enduring. Lower courts must now treat Second Amendment cases with the same seriousness as any other fundamental rights case. The ruling also provides a roadmap for dismantling a century of restrictions built without constitutional foundation. It signals to elected officials at every level that the Constitution is binding, not a suggestion. "I shall not be infringed" now carries the force of law without exception for discretionary permitting systems, population size, or subjective justifications. Here's where things stand now. States in open legal defiance are attempting emergency tactics, but courts are striking down overbroad measures. Gun rights organizations are actively litigating in over 25 states, using the new framework to challenge the remaining restrictions. Political battles at the federal level are intensifying, setting the stage for the 2026 elections. Constitutional standards, text, history, and tradition are now being applied to as many as 40-80 existing gun laws nationwide, placing them on borrowed time. This is not the end of the story. It is the opening chapter of the most consequential legal battle over the Second Amendment in American history. Anti-gun politicians know it, which is why emergency sessions, rapid legislation, and intense litigation began immediately. When a constitutional right is fully restored with a durable majority and a clear legal standard, the system that profited from restricting it will resist. But history shows such resistance cannot withstand a firm constitutional foundation. For gun owners, staying informed is critical. Know what is happening in your state, in your federal circuit, and on Capitol Hill. Keep up with every ruling, injunction, and legislative move. The next court decision or legislative session could come at any moment. Like this video, subscribe, and turn on notifications. Share this information with other gun owners who need to understand what's actually happening. The more people who know the truth, the harder it becomes for any politician, governor, or bureaucrat to undermine your rights. The Supreme Court has reaffirmed the right to keep and bear arms is fundamental, durable, and no longer conditional. The map of American gun law will never look the same again.